Well, we are here with our sponsor, Greg Niblock, attorney and founder of Niblock and Associates, to talk a little bit about what happens, of course, when debt goes bad and the 4 phases of fighting a collection lawsuit. And your last several visits, you've just kind of been taking us through the process and telling us what's going to happen each step of the way.
Yes, ma'am.
Right. And now we're talking about they're suing you.
Right.
Right.
The lawsuit's been filed and you've been served, and now the choice is, will you file an answer and fight it, or will you just let them get a default judgment?
Okay.
So if you want to fight it, you're required to file an answer with the court. And then after that, the next phase is what is called the discovery phase.
Okay.
And generally in a collection lawsuit, there's not going to be much discovery, but sometimes there is. And this discovery is just trying to find out what information each party has, and can it be used to aid and assist in the defense or prosecution of the case. And we have things like interrogatories, which are merely written questions that you have to answer in written form and under oath. You have requests for production of documents. You could actually do this too and say, hey, what contract do you have? What do you have that shows that I owe the debt?
Yeah.
And then they could ask, well, what proof do you have that you paid on the debt? Things of that nature. And then there's requests for admissions, which I think is the most insidious thing, because you can say, admit that you owe the debt, admit that you owe $5,000, admit that this, admit that. And if you fail to answer it in the appropriate time or in the appropriate manner, the court will deem that admitted. And if you admit you owe the debt, you owe $5,000, well, guess what? A judgment's going to be rendered against you.
The judge is going to say, you admitted to it, right?
And that's the end of it.
So that's sort of just finding out what each side has, right? What you have. Okay, then phase 3 is the trial.
Is the actual trial. And let's be clear about this. When you go to court, it's not a court of mercy. You can't just say, well, I can't pay this. My aunt had cancer and I had to do this or that, or I was sick. The question is, do you owe the money or not? It's a court of justice, and there's a huge difference between justice and mercy.
Right.
So anyway, the court's job is to listen to the party's case, because each party will have an opportunity to present their case, present any evidence they have, any testimony they have, and the other side, of course, can cross-examine the witness, just like you see on TV. And then after that, you make your closing statement, and then the judge makes his ruling. And in most collection situations, it's pretty much a foregone conclusion that you owe the money. Right. 90-something% of the time. So the judge is going to have to render a judgment against you. So, the gavel comes down, and it's a court of justice, and justice dictates that you are going to owe the money most of the time. Now, of course, there are situations where it may be that you don't owe it, and you can show the court that you don't.
Most of the time, though, it is.
It's going to be a judgment against you, and you may say, well, hey, that's just a piece of paper. It says I owe the money. I knew I owed the money before. What's the difference? Well, next phase is called the execution phase. Okay,
that sounds scary. Execution anytime in a court of law, but what does that mean?
Well, after there's a judgment rendered against you, the creditor has the full force of law behind that piece of paper, and they can file something called a writ of garnishment and serve that upon your employer or your bank, and it turns your employer or bank into a collection agent for the creditor, and they'll hold the money out of your check, or they'll suck all the money out of your banking account, and your checks will go bouncing around, and then send it to the creditor. The next thing is a writ of execution, and that's where the sheriff can go to your home or wherever you are and marshal the assets that you have. In other words, the property that you have that they can take and go sell at an auction. Now, that doesn't happen just a whole lot, but I've seen it happen in several occasions.
And that could be your home, your car?
Well, generally it's going to be personal property.
Okay.
So it could be if you have guns, you have things like that are of value. I mean, your clothing and whatnot, what's that going to bring?
A boat, a car,
yes,
something
things like that they can take.
Okay. And then a judicial lien against real property.
Okay. If you own property, real estate, and there's a judgment rendered against you, by operation of law, a judicial lien attaches to that property. So if you were to try to transfer that or sell that or refinance that before you're going to get a good mortgage on it or give good title to whoever it is, you've got to satisfy that judgment lien against it. So in order to satisfy it, what do you got to do? You got to pay it. So it's going to be the amount of the judgment, the court costs, attorney's fees, and any interest that is accrued on it. So it's like you're putting a chain around your house or whatever real estate you have until that is taken care of.
Yeah.
Now,
just like when you're ready to sell your house, you have to show it has no liens on it.
exactly, and that's what we're talking about.
I think we're almost out of time, but we want to let everybody know you can file bankruptcy at any point.
At any point in this process, and you can knock that debt out. In fact, you can get rid of that judicial lien, you can stop the garnishment or writ of execution, and get your fresh start. And we'd love to talk to you. And if you'd like, you can call. And the first 50 folks that call, we'll send you this book, The Devil Filed a Lawsuit, Heaven or Hell, Your Choice.
It's your second book.
It's the second book.
That you've been giving away, and you can get that. There's the information on your screen of how you can reach, of course, Niblock and Associates, and if you feel like this is the answer for you, and for a lot of people it is, you can also go to the website as well. Thank you so much.
Thank you so much.
We appreciate it. Okay, back in just a moment after this, Chris is having his super